The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 515-207-2006. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Iowa. We're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, I'm Gene Nassif, an attorney at O'Flaherty Law. My practice areas include business transactional matters as well as some landlord-tenant and probate issues. Now, today we're going to talk about when someone can reopen an estate in Iowa. Probate cases are often troubling times for families. Not only is a person going through the loss of a loved one, but the probate process is often confusing and stressful. Sometimes this process can go on for several years. The estate will usually be closed within 3 years. But what happens if an issue relating to the estate happens after the estate is closed? What if new assets are discovered which need to be distributed? Iowa law allows estates to be reopened under certain circumstances. Today we're going to talk about those. Now, what is the general probate process? When somebody dies, their estate enters into probate. A personal representative will pay any debts of the estate and distribute the property to the beneficiaries. If the person left behind a will, the property and assets will be distributed to the beneficiaries as outlined in the will. If the person did not leave behind a will, the property will be distributed by a statutory process called intestacy. In either case, the personal representative accounts for all known assets and distributions and files a final report with the court. This process is usually completed within 3 years, and all payments and distributions are made within that time period. Now, when can somebody reopen an estate to challenge the accounting or the distribution? Usually, a person cannot reopen a will after probate is finished. However, Iowa Probate Code does provide exceptions. These exceptions are listed in Iowa Code Chapter 633, Sections 488 and 49. 488 has to do with reopening an estate to question the personal representative's final accounting and distributions. As mentioned previously, the personal representative is responsible for distributing assets and preparing the final accounting. Within 5 years from the entry of the order approving the personal representative's final report, some people may apply to reopen the estate to question the accounting and distributions. The court may reopen a hearing on the report and accounting. The court may open a new accounting and order new redistribution of the property. If someone to whom the property was distributed has already sold it, the purchaser will not be held liable. Someone to whom property was distributed will also not be liable for more than what they received. Now, when can a estate be reopened with no time limitation? An estate can be reopened without any time restraints under Code Section 633, Section 489. The court may reopen an estate under this code or chapter if other property not known during the probate is discovered, any necessary act remains unperformed, or there is another proper cause for reopening it. As there is no time limitation from this section, parties who do not wish the estate to be reopened will argue that the petitioner's claim actually falls under 488, which has the time period limitation. There has been case law involving this section. District courts exercise discretion in determining what qualifies as any other proper cause. This section has governed situations where plaintiffs seek to change the estate's administration in a way not contemplated during the probate. For instance, in one case, the property was found buried underneath one of the decedent's properties. As the property was not contemplated during probate, the estate was reopened. Section 633-489 has also been applied to reduce improperly awarded executors' fees when they were improperly accounted for due to a mistake. Section 488 only allows the court to hold another final report hearing, order new accounting, or order redistribution amongst the beneficiaries. Section 489 allows the administrator to perform transactions and other substantial acts. Now, will an estate be reopened due to fraud by the personal representative? A personal representative is the fiduciary primarily responsible for administering the estate, paying debts, and distributing property. Iowa Code specifically states that other time bars or limitations on rights do not prevent an action against the personal representative for fraud. The court will probably not reopen an estate due to fraud by the personal representative. The court has reasoned that recovering damages from the personal representative does not necessitate reopening the estate. It has been reopened under very limited circumstances for mistakes by the personal representative, but the court has distinguished making mistakes from fraud. As always, if you have any additional questions, feel free to reach out to our firm. Thank you very much, and have a nice day.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed this video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 515-207-2006. We have many locations for your convenience. We serve all of Iowa. Thank you again for watching.